You're all very welcome. Thanks for coming today. And thanks for those that are here in person. And I know there's also quite a number of people that are joining us online. So thank you too for joining us. So we're here for the launch of the independent research report on enforcement and remedies for the Windsor Framework Article 2. And at the Commission, we're really pleased to be able to continue to attract experts to assist us with this research. And it's really complex, as you know, area of law. And the reports that have been produced are so comprehensive and authoritative. We're very lucky to have the research team to support us. At the Commission, as you probably all know, we take our mandate to protect and promote human rights seriously, as you would expect. And producing robust, high-quality research is an essential part of the work. Today's research from the team is the latest in a series of independent reports that explores what the UK government's commitment to the Windsor Framework Article 2 means in practice. And as you will all know already, the Commission has a broad mandate in this regard, and our research helps build a robust basis for our advice to government, for our legal work, for our awareness-raising functions, education and information, and also for our international reporting responsibilities to the Council of Europe and the United Nations. Today's launch is an important opportunity to engage with you as a community of interest, and also we recognise your expertise in the room and online. And it follows hot on the heels of the annual statement from the Commission, which was launched last week at Stormont, and which provides an overview for the human rights landscape in the jurisdiction in 2025. The annual statement, and again, you probably already know this, but the annual statement tracks and collates our recommendations to government to promote, protect and fulfil the enjoyment of human rights for everyone in Northern Ireland. And it also vitally includes, and more so over the last few years, the analysis in multiple areas of social policy and law that are affected by Article 2 of the Windsor Framework. So if you haven't got a copy of it already, and they're pretty rare but also very large, please feel free to go online and have a look at this year's annual statement. The Commission's broad education mandate means that we engage with a wide variety of rights holders and duty bearers, and it takes us into schools, and our team's here that does that work today, where we work with children and young people to help them understand the issues that matter to them and what human rights means for children and young people in practice. We also have work with sports and human rights with a forum, and it creates a space for local sports governing bodies and local organisations to share knowledge and good practice on how to embed human rights within all levels of sport. And we also work with the private sector and government to promote the UN guiding principles in business and human rights, including substantial work on public procurement. Increasingly, all of this additional information and education activity benefits from the volumes of work now that are being produced by the in-house team charged with the Windsor Framework mandate. And I could go on for a long time talking about all the work that they have done. I could also take you through, and you'll already be aware of it, the cutting-edge legal work that's being done by the team in-house and the advice to government, but I'm not going to. I'm going to stop there. All I want to do is to thank the team, the in-house team. We're heading towards the end of the year, and their work is incredible. Very hard work, extremely complex area of law. And I'd also like to thank all of you for your continuing support for the Commission. And for contributing to today's event. So we're very happy to welcome you and the team to present the research. I'm delighted to invite Alison, the Chief Commissioner, to take us through it and to chair the event. Thank you.
Good morning. I'm very happy to add my welcome at the launch of the latest in our series of independent publications on human rights after Brexit. I think it's particularly gratifying that you continue to be interested in and appreciate this work. We're really grateful to have been able to secure again highly esteemed independent experts, and their contribution has been and continues to be invaluable. This research is published at a critical time. We're awaiting judgment from the Supreme Court in the Dillon case, and there will be a number of cases almost certainly affected thereafter. Since being charged with responsibility for monitoring implementation of Windsor Framework Article 2, we have been careful, methodical, and rigorous in our analysis and response. We have treated this subject with the utmost respect that it deserves, because it has both short and long-term consequences for people. What we are concerned with is not a trade deal, a political fudge, or diplomatic camouflage. It is as basic but important as the agreement that underpins it. It is about the protection of fundamental rights and equality, understood as critical to securing the Belfast Good Friday Agreement. For governance and accounting reasons, we sometimes talk about the dedicated mechanism and core human rights work as if they're different, but they are indelibly linked. Windsor Framework Article 2 simply protects that part of the Good Friday Agreement and subsequent law that was undermined by withdrawal from the EU. Our annual statement, which was launched last week, weaves Windsor Framework Article 2 throughout, and as we keep reminding government, they also have an obligation to weave Windsor Framework Article 2 throughout their policy and lawmaking. So I said it was simple. That's not entirely true. The principle is simple, but the application less so. So we've worked hard to understand what Windsor Framework Article 2 really means in practice. We've done this in-house through our own legal and policy work, and we've developed a research programme. This year marks 75 years of the European Convention on Human Rights and 25 years of the EU Charter of Fundamental Rights. It's undoubtedly a time for celebration and reflection, but it is also a precarious moment for rights protection. Windsor Framework Article 2 was carefully designed to insulate us in Northern Ireland from the worst erosion of rights following Brexit. We still need it. It was meant to last, but it is under challenge. The government has stated its commitment, and that's welcomed. However, the submissions made by government before the Supreme Court called for a very limited interpretation of the non-diminution commitment that would mean it could only be relied on before the courts in the most marginal of cases. In our view, that is a mistake and would render the commitment void of substance. If the commitment is undermined, rights protection is undermined. Our programme of research is to better inform us of the scope of the commitment, but also to enable us to better fulfil our statutory functions, to advise and, if necessary, enforce the commitment. I do think the value of this careful, methodical, realistic approach has been acknowledged by the courts to date. This most recent piece of research further illuminates the Windsor Framework Commitment and gives it real effect. If rights are to mean anything, they must be realised so as to be practical and effective. That's equally important here. For a right to be practical and effective, an affected person must be able to rely on it in a court or tribunal, which must in turn be empowered to provide a remedy. The Court of Appeal has made it clear that diminution, prohibited by Article 2, can result from reduction in the substance of a right or deprecation in the efficacy of available remedies. And this research explores how EU law rights were enforced before Brexit, both by EU institutions and in UK law. Really grateful to our researchers for doing that, because it isn't straightforward and it's a lengthy task. But what this does is provide analysis of how the withdrawal agreement and the Windsor Framework operate in practice to ensure the enforcement of and remedies for breach of Windsor Framework. It works through specific elements of the withdrawal agreement and domestic law's operation, where there is a diminution of rights contrary to EU minimum standards under Windsor Framework Article 2. And what this analysis includes is consideration of remedies available where the UK had not adequately transposed an EU measure prior to Brexit, analysis of the application of the right to an effective remedy in the EU Charter of Fundamental Rights, and reflections on EU law concepts such as direct effect and state liability. This report looks closely at the roll-off and remedies available in domestic courts for breach, and explores, importantly, how the oversight mechanisms also operate, in particular, how they interact with the non-diminution commitment. What we now have, thankfully, is a collaborative community of experts who've helped us to give effect to our duty to promote and protect human rights. And 4 members of that community have joined us today. I'm going to share with you a little bit of their bios, because with these particular individuals, it's often said they don't need an introduction. And I'm sure that's true, you probably all know them. What that means, however, is that they don't get the introduction they deserve. And that's a reflection on the level of their expertise and the real, how lucky we are to have them doing this work. So I'm going to say first about Dr. Sylvia de Mars, who's online, unfortunately isn't able to make it in the room. Reader in transnational public law at Newcastle University. I can see her, I'm not sure. Oh, you can. I didn't even see that behind me. Hello, Sylvia. Reader in Transnational Public Law at Newcastle University. Her current research centres on UK conceptions of sovereignty and the various dimensions of Brexit affecting the UK. Her writing in EU law, and particularly on the free movement of people, has been cited by the European Parliament and the European Court of Justice. She has appeared as an expert witness in both the House of Commons and the House of Lords on a wide range of issues. Welcome, Sylvia. Also, we have to my left is Anurag Deb, who is a PhD researcher at Queen's University Belfast and a paralegal at KRW Law. You were fortunate to get him, we're a bit jealous. He holds an LLM distinction in human rights law. His research broadly concerns public and constitutional law with a particular focus on legislative drafting in the UK. Professor Colin Murray at the far left, Professor of Law and Democracy at Newcastle University, where he teaches constitutional law and counter-terrorism law. His research spans challenges to democratic constitutional order, including the human rights implications of special counter-terrorism powers and the implications of Brexit for Northern Ireland. He has appeared as an expert witness before multiple parliamentary committees. Professor Aoife O'Donoghue, to my immediate left, is Professor of Law at Queen's University Belfast. She has extensive knowledge of the particular international, legal and Irish constitutional issues that arise from Brexit. She's published directly on these questions, bringing together the international legal obligations of the Good Friday Agreement, the impact on human rights provision in Northern Ireland, and the constitutional ramifications of these changes. Aoife has given policy advice to several political parties and NGOs on these topics. I would also like to mention Dr. Eleni Franciou, an Associate Professor of Public Law and Human Rights, University of Durham, who's unfortunately not be able to join us in the room or online, but we are extremely grateful to her for her continued support and contribution to this report. So I hope you think it was worth me saying a few words about the people who've put their time and effort into this research. It's not incidental that these are real experts who care about protection and promotion of rights, as well as these more knotty, maybe what some people call academic problems. Remember, this is not academic. It may be when we're considering for, some technical remedy, but what it means is that people get to access rights, and our rights in Northern Ireland are protected despite Brexit. So without more, I want to hand over to those experts. They're going to talk us through the report. And I think we're starting with Professor Colin Murray. Oh, no, with Dr. Aoife. Thank you.
And thank you both for that lovely introduction. So I'm going to get straight into the report. And what we aim to do here is to kind of give a brief introduction to the contents, because this is quite a detailed report, so we won't keep you here all day going through it in detail, but kind of give you the highlights. So across the report begins, and I will talk about this in a bit more detail, outlining Article 2, the Windsor Framework and how it works. We'll then look at public enforcement of EU law and remedies and breaches of EU law. We then look at the private enforcement before national courts and its interaction with EU law. We'll then move on to remedies for breaches of Article 2 specifically. And then we will look at the end at the withdrawal agreements remedial mechanisms. So each of us will address each one of those specifically today. So over the report, as I said, we start here with the broad, looking at Article 2, looking at as a broad commitment. As we mentioned in the report, there's some excellent work, and the Chief Commissioner has already mentioned reports that have already been done, so we're not going to go into the substantive of specific areas there, but look at it in a more broad, what are the broad commitments and the remedies attached to them. And then look at the way that affected parties can use different forms of legal redress in domestic law and where that's going at the moment, or it could potentially be going. We'll then look to see how EU law is enforced both publicly, so by the Commission in the system prior to Brexit here, but also privately between private parties and national courts, and then seeing how those operate or should function or operate. We will then look at the remedies, so who will take over, what was the Commission's role historically in ensuring what happens when breaches take place, because one of the elements that Brexit brought about was a change in the role of the Commission, ensuring the enforcement of EU law within states, and what remedies were available prior, and then what is there now. that the Commission's role has been changed. But also, what do national courts do, particularly in the UK? What do they now do? Particularly because the way that the withdrawal agreement and specifically the Windsor framework operate and reference different forms of EU law, depending on the context in which they're used and who exactly has the oversight of it. We will then look at the actual withdrawal agreement itself and its remedial mechanisms, and specifically at Article 2, because that is also a broader question. So I'm going to start with, very briefly, going through Article 2 of the Windsor Framework. And this is just bringing up the text, which I'm sure everyone in the room is now quite familiar with. But it's supposed to lay out the difference between the Part 1 and Part 2 of that, one being directly related to the rights and safeguards in the Good Friday Agreement, the second half being led or connected directly to directives, 6 specific EU directives, all of which are listed in the report itself. And we will be looking at the differences between those 2 sections and what that has meant in the way that the courts have operated. So just to do that in a little more detail. So as already has been alluded to, the no diminution element of it is extremely important and significant, and how we interpret that and how the courts will be interpreting it as well. The Supreme Court is important when we understand the operation between the first 2 parts. So looking to see the date of Brexit for the first half, but also then the second half with the dynamic alignment. So the idea that as those directives change, the law within Northern Ireland will also change. So the process of dynamic alignment alongside the idea of no diminution for the second part, but then no diminution in the first, and understanding what that means when the Court of Justice of the European Union will continuously interpret those rights. So the difference between non-diminution and the role of the Court of Justice of the European Union as the ultimate arbitrator for all time, pretty much, of what EU law actually means and how we should interpret EU law. So the kind of 3 different kind of temporalities or times that are going on that we have to be aware of when then moving to look at what remedies might be available. So a few things to highlight, and this sort of goes on from what I've just said, is the references to union law, and this is reiterated in several different parts of both the withdrawal agreement but also the Windsor Framework, that union law means EU law. It means as interpreted by the Court of Justice of the European Union. And that is extremely significant because it maintains a role of the Court of Justice of the European Union in being the ultimate arbitrator of what it means. Not on the date of Brexit, but now in the present. So when we are looking to understand EU law, we must look to understand there. Now, in the Court of Appeal, that was, and this is going to come up later, one of the presentations, the Court of Appeal way of interpreting that is, I suppose, we would disagree with, but one of my colleagues will address that later on as well. But that union law means both primary law, so the treaties, but also secondary sources of law, including the kind of wide array of core concepts that EU law operates under. So I've just listed 2 there, but things like proportionality and equality, which are used across EU law and how we interpret it. So when we say EU law, it is, yes, the sort of what you can find in the treaties, what you can find in directives, but also the broader texture of what EU law, how one goes about reading it and interpreting it. All of that is encompassed in every time you see union law in both the withdrawal agreement and the framework. A very significant and important part of it, and you can see it in the Withdrawal Act itself, is that the remedies are recognised and available. And both of those parts are extremely significant and kind of feed into everything that follows in the presentations. And this is reiterated in the courts in the Alistair judgment, that it is the possibility of remedy is recognised, and we can see that already in the way that the courts have been interpreting Article 2, but also that remedies are available and that there has been no removal of the forms of remedy that were available. So if union law is there, it must be interpreted as according to the Court of Justice of the European Union, but that there must also be a possibility of remedy, both for the individual, for private actors, but also between private actors and the state. And then we'll come back to the role of where the Commission would have been the ultimate arbitrator previously of whether or not a state was complying, what we think that the role now, where that sort of compliance comes in, as well as through the various committee structures. So I am now going to pass over to my colleague, Sylvia, I think. Sorry, I left out my last bit. But that also the role, of the European Convention of Human Rights and the CFR rights. Again, these are both particularly significant in the way that, particularly, which will come up, Article 27 of the CFR about right to a remedy. And that has been the most used a part, actually, of the CFR. And that those parts, and that they are, and again, when we talk about union law, we are still talking about fundamental rights. So those rights, while they were taken out of UK law itself, the Charter for CFR, the Charter for Fundamental Rights, remains part of how we understand union law and how we have to interpret union law, including the rights to a remedy that are there and is actually the most enforced part of the CFR. I think that brings me to Sylvia now.
Oh, it does.
Can you move the slides, or do I stay?
Well, I can't touch the slides. I can't do anything with them. I also can't see the slides. I can see myself. There we go. All right. Is everyone okay with just listening to me, not seeing my face this morning? I think that I'm doing everyone a favor, but there we go. A lot of this report was basically, Eleni and I had a really good time because a lot of what we did was a run through of basically foundational EU law, which our students absolutely hate, but here we have an attentive audience for, so this is very, very exciting. The first thing I wanted to say, and we started the report with this just because the common law and EU law use terms slightly differently, all right? Remedies in the common law, as far as I understand, are the legal avenues for getting redress. That's not how the EU uses the term remedy. For the EU, a remedy is the actual thing you get once you won a court case of some kind. So it might be damages, it might be some sort of disapplication of the law. Enforcement is what we would call the avenue for getting to the courts and making sure that the correct law is being applied. All right, so those are the main things we were looking at. Now, there's two dimensions of enforcement. Thank you very much, Aoife. The first one is the public side. Obviously, being an intergovernmental institution, the EU is very concerned about EU law working within its member states, right? So one of the jobs that the European Commission has, not to be confused with the commission that is hosting the event that we're all at today, this is the European one, it does something called infringement proceedings. Basically, whenever a member state is thought of as not complying with its EU law obligations, the Commission can investigate that. And if it thinks the breach is bad enough, it can drag that member state to the Court of Justice and get a ruling against the member state if the court agrees. That is the main public enforcement mechanism in EU law, right? So it's done by one public institution, the Commission, against member states rather than private individuals. The infringement proceedings have some shortcomings. We go into a lot of detail about those in the report, but for now, it's just important to realize there's this dimension of an intergovernmental institution coming along and saying, hey, you were bad, we're going to take you to court. All right, next, please. Thank you. Beyond that, this chapter discusses how the EU approaches actual remedies. So what do you get if you go to a court and it finds that something has gone wrong in terms of your EU law rights? The basic EU approach to this has always been very, very hands-off. There's a principle called the principle of national procedural autonomy, which basically means that the Court of Justice has said, look, the treaties are silent on remedies for breaches of EU law. We just need there to be effective and equivalent remedies to what you would get for a similar breach of domestic law. So if a domestic law was breached and what you would get for that is damages, the same thing needs to be available in an effective and equivalent way for a breach of EU law, right? That's the overarching way in which EU law has an influence. And most of the case law on this is really about remedies not being effective, meaning that they're hard for people to access, or they're sort of token remedies. You get sort of like an apology and £5, but you don't get anything meaningful out of the court. Those kinds of things are when the court goes, no, that's not an equivalent or an effective remedy, and it pursues that. Next, please. This has been massively bolstered by what Aoife already alluded to, Article 47 of the Charter on Fundamental Rights. I'm going to be very, very brief on this because Eleni is our charter head, if we may call her that. She is the expert on this side of things. Article 47 establishes, as a matter of primary EU law, the right to an effective remedy. And it's a directly effective right. I'll come back to that, meaning you can't actually just go to court and claim, hey, I didn't get an effective remedy for this breach of EU law in a member state. And the courts have to hear that and then award an effective remedy. So it's been a massive way of bolstering this enforcement dimension of EU law in national courts. All right. That said, the remedies that you get still to be determined by the national courts as long as they're effective and equivalent. All right. So it helps access to those remedies, but the overall system is still quite hands-off. There's one exception to this in EU law. It's going to see if Aoife can read my mind. There we go. Which is the one specific remedy the Court of Justice has designed. And this is basically one for misbehaving member states. If a member state breaches EU law in a way that causes harm to an individual, and there's a clear causal connection between the harm and the failure to act or the action of the member state, that member state is liable in damages to that individual. Right? This is the principle or the doctrine known as state liability. In the UK, it's sometimes also called Frankovich damages, is something you'll hear it called. And it is a way for a private party to basically hold the government to account when it's not complying with EU law. All right, so we have lots of evidence of there being long-lasting breaches of EU law in a member state and someone being awarded damages because the member state should have addressed the problem sooner than it did. So those were the things that existed in terms of public enforcement and remedies prior to Brexit. What do we have after that? Our survey suggests, well, nothing really replaces the Commission. That level of oversight of being able to drag the UK to court, as it were, and say you're not complying with EU law, it's basically just gone. There's two minor exceptions. When it comes to citizens' rights in Part 2 of the withdrawal agreement, the Independent Monitoring Authority, which I hope we're all familiar with, it has a lot of the powers that the Commission used to have. It can investigate breaches by the UK government of the obligations in the Part 2 of the withdrawal agreement, and it can try to enforce those in courts, right? So that's good, but only if we're looking at breaches of citizens' rights. Beyond that, everything else has to now be resolved at a political level by the Joint Committee. That's what's replaced the role of the Commission, all right? That's a big difference. Now, beyond that, as far as remedies go, the most important provision in the withdrawal agreement is Article 4. I mean, it's the only one that I think most of us can quote from heart at this point in time if we're looking at this enforcement dimension. It requires that the entirety of the withdrawal agreement produces, in respect of and in the UK, the same legal effects as what is produced in the EU and its member states. This means that whenever any provision of the withdrawal agreement is considered, it has to be accessible, produce effective remedies in the way that it would in the EU. More than that, Article 4 also requires that any provision of the withdrawal agreement that mentions EU law needs to be in application and implementation, interpreted in conformity with pre-Brexit Court of Justice case law. I could go on about this for a very long time, but I won't. The main thing that matters for our purposes, for remedies, is that all of these remedies were established well before Brexit, right? So state liability created by the Court of Justice well before Brexit. National procedural autonomy and this idea of an effective remedy existed long before Brexit, meaning that that is case law from the Court of Justice that needs to be applied to any interpretations of breaches of the EU law provisions of the withdrawal agreement. All right. So there's then big debates, mostly academic, about whether or not, is, the national procedural autonomy, is that a method of EU law? Is it a general principle of EU law? We don't have a direct answer, but it's very likely that the Court of Justice, if asked, would say, well, yes, this is how we've asked for EU law to be interpreted and applied for decades. So yes. State liability, likewise, big questions about whether it is a general principle or method, but we don't have a definitive answer, and we won't until a domestic court considers if it fits that description of things that are maintained by Article 4. That's the withdrawal agreement. In the Windsor framework, slightly different. The Commission's more involved, but the Commission's only involved in enforcing the trade border, right? That's the aspect, the part of the Windsor framework where the Commission becomes involved. Enforcement before local courts, much the same as it is the rest of the withdrawal agreement. Same sort of obligations to keep effective and equivalent remedies in place. However, then you get to Article 2, and I'm going to leave that there because I think Anurag will speak to that on a later slide. So I'll just leave you with the questions of wondering how this system of remedies applies to Article 2. All right, next slide, please. Thank you, Eva. Now, in terms of how national courts interact with EU law, this generally starts with a right they've had in the treaties since the dawn of the treaties, which is the so-called preliminary reference procedure. It means that any national court, literally at any level, magistrates upwards, whatever, can ask the Court of Justice a question about the meaning of EU law before it, right? So if you're a domestic court somewhere, you get someone say, hey, this EU law has been breached. You have a right to ask the Court of Justice, what does this EU law mean? How should I interpret it? It's meant to be a purely informative duty, but in practice, obviously, it means you get the Court of Justice writing back and saying, well, we think in this particular situation, this is the thing that it means, which leads to outcomes in cases a lot of the time, all right? It doesn't decide the cases through the preliminary reference procedure. It sends them back to national courts, but a lot of the time, a clear definition of what the EU law requires means there's also an answer to the question before the national court, all right? Now, when a national court hears a case, there's a couple of EU law doctrines that apply. The first of these is primacy. If there's a clash between domestic law and EU law, domestic law has to be set aside. Doesn't matter what kind of national law it is, if there's a clash, EU law comes first, and the court has to apply the EU law. The UK loved this dimension of EU law, obviously. I'm a huge fan of primacy. Direct effect is a corollary of that. Direct effect is the doctrine that gives individuals the rights to rely directly on EU law in national courts, right? There's specific trigger conditions for it. Not all EU law is directly effective, so you can't go to a national court and say, hey, the EU law has a goal to create 50% women in boardrooms or whatever. Is that something I can rely on? No, that would not meet conditions for direct effect. But if a provision is clear, precise, and unconditional, not just a goal, not just an aspiration, you can go to a national court and say, hey, this has been breached. When you combine that with primacy, it means national court has to go, oh, it probably has, set aside the conflicting national law and give you what you are asking for. Where EU law is not directly effective, the Court of Justice has gone, well, you know what? There's also indirect effect, which comes with primacy. It is the obligation for national courts to interpret EU law, to interpret domestic law consistently with EU law. What this means is if you've got a national law provision in front of you that says something like, if there's a breach of equal treatment rights, you get £20, and there's an EU directive that says, actually, if there's a breach of equal treatment law, you get an effective remedy, then the obligation for the national courts is to see, can we read £20 to meet an effective remedy? Or if not, can we increase it in some capacity? Can we do something to give effect to this EU law? This is a very widespread obligation. It has huge impact because the national courts have to look at the whole domestic legal system and make sure it complies as much as possible to give effect to this EU law that's been breached. It's huge. And the consequences of it are slightly unpredictable, but it's one of the main ways in which the EU, or the Court of Justice in particular, has gone, let's make sure that the laws that we write actually work in the member states. Otherwise, what's the point, right? Now, all of this is reinforced by Article 47, which again, people can rely on directly, and they can basically just say, we are not getting an appropriate remedy out of this, and consequently, we need to have that addressed, right? So, where are we since Brexit? There's a whole slew of provisions there that tell us that a whole bunch of stuff has taken place somewhere, but it's all quite different, at least on the surface. All right. Citizens' rights, again, continue to be enforced in a different way from everything else in the withdrawal agreement, meaning that for at least 8 years since Brexit, and every time I mention this, I'm like, oh my God, we're almost there, aren't we? Like, we're hitting that 8-year deadline pretty soon. National courts in the UK can ask the Court of Justice preliminary reference questions about Part 2 of the withdrawal agreement only. There's this extra layer of security built into citizens' rights protections, right, as they are in the withdrawal agreement. Beyond that, we at most get sort of like a roundabout way of preserving preliminary references and that sort of Court of Justice level input, in that if the EU and the UK fundamentally disagree about something the UK is doing and take that to the joint committee and then to arbitration, the arbitrators have an obligation in Article 158 of the withdrawal agreement to ask the Court of Justice for the meaning of any EU law concepts that are at stake in that arbitration. So the UK worked quite hard to get rid of the Court of Justice as much as possible in all of this, but at the end of the day, the EU just said, no, we can't have random domestic interpretations or random international interpretations of EU law. If EU law needs to be interpreted, it's got to be done by the Court of Justice. It's different. It's not as effective and it's not accessible by all the courts. But it's still there. Now, as far as domestic enforcement goes, we look at Article 4 again, right? All Court of Justice case law from prior to Brexit has to be applied when interpreting the withdrawal agreement and the EU provisions in there. The whole of the withdrawal agreement has been given primacy in Article 4. It is superior to all domestic law in the UK and in the EU member states, right? That's a big deal. That's very important. Article 4 also makes it clear that the provisions that would have been directly effective prior to Brexit in the withdrawal agreement are still directly effective now, meaning that there are parts of the withdrawal agreement private parties can still go to court and try to enforce there, with primacy and everything. Article 4 also implies, much in the way that it sort of implies that consistent interpretation still, or that state liability still exists. It implies that consistent interpretation still exists because it's part of the Court of Justice's case law. It's a general interpretive principle that the court applies to all of this. So again, we get into that funky debate about what is a method of EU law, what is a general principle of EU law. It's very likely this maintains and this continues to exist. So domestic courts have to treat the withdrawal agreement basically like it's EU law and like they are still dealing with us as a member state. Right? Withdrawal framework, once again, a bit distinct. First of all, Court of Justice case law there stays up to date forever. It's all new case law that also applies, in particular when it comes to the border provisions, so Articles 5 through 10 of the the Windsor framework. And beyond that, we get to Article 2 of the Windsor framework again, where again, things get a little bit stranger. Now, some parts of Article 2 refer to EU law. It's clear that Court of Justice case law about that underpinning EU law in Annex 1 still applies. Article 13 makes that pretty clear. But what about the rest of Article 2, which deals with non-diminution outside of EU law? So the rights, safeguards, and what are the other things?
Equality of opportunities. Are you
Thank you,
looking
thank
for me
you.
to actually answer that?
Waiting for someone to chime in there. Thank you. I appreciate it. All right. So the RCO, as it just is in my head, those are not themselves EU law. They're underpinned by EU law, but they're not themselves EU law. So there it seems like Article 4 applies, and only the pre-Brexit Court of Justice case law applies in interpretation. I mean, this gets so messy, right? This is so strange. Some parts of Article 2, yes, current case law, other parts, maybe not. Now, preliminary references is another one of those hotspots. Doesn't seem to apply to Article 2 of the Windsor Framework. So if a domestic court has a question about how Article 2 of the Windsor Framework works, it's not covered by the preliminary reference. They can't ask the Court of Justice. An argument can't be made. That's a big diminution. Because in the past, had there been any questions about a provision like this originating from the EU and how it worked, you would have been able to ask the Court of Justice about it. And asking the Court of Justice might have gotten you an outcome that you otherwise would not have arrived at. Is that a diminution? It's debatable. It's debatable. If a national court should have been able to ask and should have asked the Court of Justice for clarification, and it now no longer can do so about how a bit of EU law works, that's a diminution, right? So, very, very messy stuff with real consequences for people. I'm going to leave it there, and I'm going to pass over to the next victim.
Thanks, Sylvia. Hi, everyone. This is, as Sylvia mentioned, the terms remedy and enforcement are used slightly differently in the EU legal order compared to how we understand remedies sometimes in the common law tradition. So what I'm going to be talking about really are domestic and EU law remedies, as understood in EU legal terminology, to enforce obligations of EU law under Article 2 of the Windsor Framework and its supporting architecture, a lot of which has already been covered. Article 4 of the Withdrawal Agreement, for example, Article 13 of the Windsor Framework, and the fact that we have to continue to understand EU law in accordance with evolving case law at the Court of Justice for the whole of the Windsor Framework, including Article 2. So there are 3 procedural avenues. These are not remedies, of course. These are just procedural avenues to try and get remedies via Article 2. Individual litigation, horizontal and vertical changes, so litigation between private individuals or private parties with no state involvement, albeit that you are using Article 2 to say that there's maybe something in the way that the state has implemented a particular EU directive which has been either incomplete or bad implementation, and therefore state liability might arise. And vertical changes, where you're directly challenging state action, you're directly challenging legislation, whether at Stormont or at Westminster. And of course, the 2 sort of most crucial Article 2 cases in recent years have both challenged acts of the UK Parliament, Dillon being the Lacey Act and JR 295 being the Illegal Migration Act. Then litigation intervention by the dedicated mechanism institutions. So they have statutory rights. The Human Rights Commission and the Equality Commission have statutory rights to take litigation and to intervene in litigation brought by people. That's incidentally one of the reasons why we say that self-evidently Article 2 is directly effective, because when the Northern Ireland Act says the Human Rights Commission and the Equality Commission can intervene in litigation, and I quote, brought by a person, that is a personal invocation of EU law, that is a personal reference to EU law. You have the right as a person to refer to EU law. That can only mean direct effect and nothing else. And finally, this is a slightly understudied bit, devolution issues referred by law officers. So we're talking about the Attorney General for Northern Ireland, we're also talking about the Advocate General for Northern Ireland, who's concurrently the Attorney General for England and Wales, but also other devolved law officers in GB, so the Lord Advocate, for example, and the Advocate General for Scotland. All of these office holders can make references under the various devolution statutes to the Supreme Court. And devolution issues typically go into things like whether the Stormont Assembly or the Scottish Parliament or the Senate have made law in breach of their legislative competences under their respective devolution statutes, or whether a minister has acted out with their own competence under the devolution statutes. But for Northern Ireland, competence involves Article 2, because the Assembly is prohibited by the Northern Ireland Act from making laws or from breaching Article 2 specifically, from making laws that breach Article 2. Ministers are also prohibited from acting in breach of Article 2. And more widely, Section 7A of the European Union Withdrawal Act 2018 also obligates the UK in general to comply with everything in the withdrawal agreement, including Article 2 of the Windsor Framework. So there's a lot of layers to the ways in which issues about competence breaches can be brought to the Supreme Court. And the devolution issue route is a rather understudied one, but it demonstrates that there's other sort of domestic monitoring mechanisms or compliance mechanisms beyond the Human Rights Commission and the Equality Commission. Substantive remedies. Now, this is a mixture of domestic and EU law remedies. Obviously, we've heard of the Frankovich rule, or Frankovich damages. Now, the Withdrawal Act in 2018 says Frankovich damages are no longer available in domestic law. That's great, but that doesn't apply to the Windsor Framework. And that doesn't apply to the EU law that comes through Section 7A via things like the Windsor Framework. So the exclusion of the Frankovich rule applies to purely domestic law that has no relationship whatsoever to EU law. In other words, what is now known as assimilated law does not attract Frankovich damages, but breaches of real EU law, including through Article 2 of the Windsor Framework, would still attract Frankovich damages if a state is liable for bad implementation of a directive, for example. And that obviously extends to the 6 Annex 1 equality directives. But also to more widely to say if a pre-Brexit directive was badly implemented in Northern Ireland before Brexit, and a person is aggrieved by the bad implementation of it, and they go into the High Court seeking Frankovich damages, they should be entitled to that, if there is indeed a breach in the implementation. Mandamus is an interesting one because of the Supreme Court's recent kind of turn in the Imam case, and the fact that the Supreme Court made it clear that courts shouldn't be too reticent about ordering mandatory relief when it comes to judicial review. Now, Imam had nothing to do with EU law. It was a local authority in England, and it was to do with a housing duty. It had nothing to do with EU law, but the point is that mandamus is now should be more widely available. And the reason why that matters is because, as Sylvia mentioned before, the Court of Justice of the European Union has historically, and continues to be, pretty hands-off when it comes to actual domestic remedies, leaving it to national courts to devise them, using whatever rules exist in your legal order, the whole of the legal order, to devise remedies that are real and effective for breaches of EU law. Mandamus is a domestic remedy. It's not an EU law remedy, but it can be used for breaches of EU law and for breaches of Article 2. In what way, for example? Now, the dynamic alignment obligation that has been referred to by Aoife under Article 13 of the Windsor Framework, the duty to keep up with the changes made to, for example, the Annex 1 directives as they are made by the EU. We also have to keep up with those changes. Sometimes those changes can't automatically be reflected in the law of Northern Ireland because the implementing regulations or the implementing primary legislation, whatever it may be, might require an amendment. So an example of this, for example, is there was a case to do with disability rights called VL. And it's to do with the appropriate comparator for somebody with a disability. If somebody is going to a court or a tribunal claiming a breach of disability rights, who their appropriate comparator might be. The Disability Discrimination Act 1995, which continues to govern disability discrimination law in Northern Ireland, expressly limits a comparator to somebody with no disability. The Court of Justice said, no, that's not good enough. I mean, it wasn't a case about the DDA, it was a Polish case, but the comparator is similar in Polish national law. And the Court of Justice said that's not good enough. You also have to account for the way that people with different disabilities may be discriminated against on the ground of their disability or disabilities of different degree. So this would require an amendment to the DDA. If there's a failure to amend it, in other words, we are in breach of the actual directive, the Equality Framework Directive that governs disability as a protected characteristic, then it is possible, and I put it no higher than that, it is possible, at least in theory, to go to the High Court and say mandatory relief because something needs to happen, whether that's a step by the relevant department at Stormont or something else. Maybe the court can interpret it itself, But something needs to happen in order to effect this amendment, because the amendment, or not making the amendment, is a breach of EU law as we have it. And Article 47 again, this is, as we've seen already, a very, very big source of creating remedies that are effective and real for breaches of EU law. This is, I mean, this whole thing is chapter 4 in the report. It starts at page 103, and this is where there's a sort of, we look at different examples and what remedies could be available for different kinds of breaches. And if you have effectively divergent systems of immigration and asylum, and this comes from the sort of JR 295 example of the illegal migration, large bits of the Illegal Migration Act being disapplied in Northern Ireland, but not in GB, albeit that act is slated for replacement with a new bill by the current UK government. But if you have this sort of divergent system, one in Northern Ireland, one in GB, and you have an asylum seeker who comes into Northern Ireland and then is dispersed to GB afterwards, are there remedies for that person? We sort of go into what the existing laws might say and how to look at those through an EU law and particularly a Windsor Framework lens. There's some exploration of legal history about habeas corpus, something I love doing, but you may fall asleep at. But these are the sorts of things that we have to look at because, again, as we have come to know, the Court of Justice does not devise remedies as a matter of everyday EU law. It leaves it to the national court. So actually the onus shifts from what remedies are available as a matter of EU law to what remedies are available domestically, and not just currently available, but what remedies can be devised by looking at the whole of the domestic legal order, which is what the Court of Justice requires national courts to do. Looking at the whole of the national legal order to see, well, what can you come up with? You have to have something. That's what the Court of Justice essentially demands. And I think, yeah. Colin.
Thank you, Anurag. Well, I suppose everything up to this part is the world that we already know. We're trying to apply a set of remedies that have existed out of EU law. We're trying to apply a set of domestic remedies and make them work, like disapplication of a statute. But the obligations under Article 2 rest on the UK as a state. And the organisation within that state, the institution that causes the breach, well, that might ultimately be a final court that does not give proper effect to the UK's obligations. So if you go to page 128 in the report, in the beginning of chapter 5, we start to go into a what-if world. All of those things that Anurag and Sylvia and Aoife have talked about could work properly, and we'd never need to get into this space. But if they don't, the withdrawal agreement sets up its own set of remedies. How do we work through a committee process? How do the dedicated mechanism institutions feed into that process? And where might this bring the Court of Justice back into the picture? Are the big questions for this final substantive chapter of the report. Now, what I'm going to do is try to present this as a flow diagram. If there's a possible UK breach of its obligations under Article 2, who gets to complain about it and when do they get to complain? You can look at any of the committee memorandum that they put out after meetings and you won't find in the specialised committee or the joint committee any mention of Article 2 of the Windsor Framework up to this point. Because essentially, even though there have been, as Anurag has said, really controversial cases, like Dillon on the Legacy Act or JR 295 and NIHRC on the Illegal Migration Act, those haven't reached up to a final judgment point that is an inadequate reflection of the UK's obligations under Article 2. It's really only at that point that the committee system has something to bite on. Up to that point, they can push it aside and say, no, the domestic courts are currently dealing with this issue. And that can still come to a resolution that meets the UK's obligations. At that point, any number of groups could identify a problem. So this could come foreseeably after the Dillon judgment, which we're expecting in the new year, if there is an inadequate view about how Article 2 works, or about how individual elements like the EU Law Victims Directive are treated by the UK Supreme Court. If either the EU or the dedicated mechanism or even other stakeholders in NI aren't satisfied with the court's approach to this, they can feed that problem into the withdrawal agreement's remedial mechanisms. Now, the route for NI stakeholders generally came in through the Windsor framework. They get access into the committee system. And the EU identifying a breach, well, again, when it comes to the UK's obligations towards NI, is this something that the Commission has on its radar all of the time? Is it something perhaps that the Irish government would put on the Commission's radar? Or more significantly, the middle route, that the job of the dedicated mechanism is to ensure that the UK is meeting its Article 2 obligations. So the likelihood is certain voices could be minimised in the process. Some voices might not be aware of what's happening unless the Commission uses its powers. And the Commission, under Article 13 of the Windsor Framework, has very clear routes, explicit routes, into the specialised committee. Now, the specialised committee on the protocol now called the Windsor Framework is the first port of call whereby any suggestion that the UK isn't meeting its obligations under the withdrawal agreement, and the Windsor Framework as part of that withdrawal agreement, can be thrashed out between the different parties. Now, it's possible that the UK might admit, oh, there's been a narrowing of the scope of Article 2, we will bring forward new legislation to clarify the position of this, and that a solution could be agreed just within those internal committee processes. And a lot of what goes on within those committee processes, it's subject to a short summary, but it's a closed-door process. We don't really get to see how those processes are thrashed out. But there are multiple phases to that process. If that first phase doesn't reach a resolution that's to the EU's satisfaction. If you like, remember, this is a UK commitment, Article 2. It has made those commitments as part of a withdrawal agreement with the EU. What stakeholders have to persuade is to the EU that the UK is not meeting those obligations under Article 2. If there isn't an agreed solution, issues can be escalated to the full joint committee under the withdrawal agreement to try to reach an understanding of what Article 2 actually involves in a particular case, or whether its general scope has been narrowed by a particular position adopted by the UK government or by the UK's courts. And if there isn't agreement within those committee processes, if there's still dispute between the parties can ultimately put that for arbitration. Now, the really important thing here is, as Sylvia discussed earlier, there isn't a direct route to have the CJEU adjudicate upon EU law and how it applies to Article 2 after Brexit. But there is an indirect route. You eventually come at the end of all of this process, and if arbitration is still needed, if there's still a dispute between the parties as to what Article 2 means, And part of that is down to EU law concepts or the application of EU law. There is the obligation on the arbitration panel to refer all matters relating to EU law to the Court of Justice. And it is that process that can ultimately bring us back to an authoritative ruling on what these EU law concepts mean in the NI context after Brexit. The arbitration panel then considers that, and it has the ability to make a formal finding of breach against the UK. So, if you like, this process doesn't end with the UK Supreme Court judgment on these questions of law. Indeed, when it comes to the withdrawal agreement special process, that's the beginning of these processes coming to play. It is not the final statement on these questions. Now, to round off, we have several recommendations coming out of the report that we want to bring to the forefront of all of your minds. They're in full in the executive summary at the front of the report, so I'll only summarize them here. The first thing is to say, on a public education function, the Windsor framework is hard to follow. It's still badged as being the protocol. If you look at the withdrawal agreement documents, you then get a series of bolt-on Windsor framework documents and joint committee decisions. All of that is very difficult to follow, and there is a huge amount of scope for a clear statement or clarificatory statement putting all of these amendments into the general structure of the withdrawal agreement or an understanding of it so that it's easily read and accessible to the general public and decision makers who have to know what's going on it. Secondly, how can the UK government adapt to that? Well, it needs to ensure when there is this mess of sources that the bodies with the education function, the NIHRC and the ECNI, have enough resources to do that job and are able to unpack this range of sources for the general public and their understanding. Secondly, when it comes to the dedicated mechanism as a set of institutions, when we're dealing with all of these different sources of law, they need to be resourced to have enough expertise to follow these developments. It is really important in the context of this that there is a regular set of papers coming out of the commissions that explain how EU law developments track and apply to the potential scope of Article 2. That becomes the go-to resource for understanding all of these elements of dynamic alignment that my colleagues have talked about today. It's essential that there is scope for what we've described as being Frankovich remedies. We cannot take the supposed exclusion of those under the withdrawal agreement legislation as applying to the application of EU law in the NI context, ongoing EU law under Article 2, and that not be a sizable diminution of how this law works in practice. And then when we're talking about Frankovich in particular, that's how those elements of the Withdrawal Agreement Act need to be understood. Again, we don't just have static obligations, we have dynamic obligations to understanding case law, and it's really important that those are being tracked actively by the Commission. And lastly, when individual litigants are so important in this picture, when litigation is almost the trigger for the withdrawal agreement's set of specific protections, there is on the commissions the duty in terms of their education function and their litigation function, an obligation to be able to explain to litigants the circumstances in which they will take things on with the specialised committee. Because the dedicated mechanism is our key tool for if the UK, through courts, through legislation or through policy, is ultimately not fulfilling its Article 2 obligations, they are the way that we get access to these special withdrawal agreement arrangements for protecting what the UK has as a set of international obligations. Thank you so much for your time this morning.
We were so rapt as everyone was speaking, we didn't give a round of applause to our other two speakers. So could I ask you, please, just to give a round of... Not sure what I'm supposed to do with that. Better put it down there, keep out of trouble. So I'm going to chair the question and answer session. We have 10 minutes, I think. And I'm standing up here so you know that I'm not to be asked a question. I'm simply directing you over here. We're joined, I'm delighted to say, by Dr. Claire McCann, who's one of our prime people in the dedicated mechanism in the Human Rights Commission. So I'm going to, if there is a question in the room, I know we have some online, so do you want me to break the ice and go online first? Where do we have the question? We have a question online. Can I direct it to that one first, please? No. No. Yeah. Monia and Reese are waiting online. There we are.
Can you hear me in Belfast?
Hello. Yes, we can. You've been given the great honour of asking the first question. You can decide amongst yourselves who takes it. Hello to Rhys Davis and Monia and Dickie Daines, KC, both very highly regarded colleagues and friends. So, Rhys, because you spoke first, do I assume you're asking first? I'm looking down here, but you're up there, obviously.
I'm happy to start. I think, first of all, thank you very much to the team and also the Commission. I think that the work that has been done to contribute to the discourse around these really, really important issues has to be applauded. And I don't think we can overstate the value that it has. I think one of the things I picked up in, I think, Silva, you mentioned that a lot of kind of what you did there was initially to look at the foundations of EU law. And I think when you look at the legal tests that apply there, it's actually quite straightforward. I think there's a conclusion at the end of the report which talks about that they're not novel or duly and complex because they're based on the arrangements that existed pre-Brexit. I think the question that I have, and I think I tend to agree with that conclusion, but I guess that there remains some doubt over how that then transfers into this withdrawal agreement world. And I think specifically, I think you finished, Colin, with speaking about one of the recommendations around Frankovich. And I think another recommendation you also talked about is the role of the dedicated mechanism in educating the public and ensuring that there's a clarity amongst individuals. But I guess my question is, I think that has to be taken hand in hand with the litigation function, not only the dedicated mechanism, but the litigation more generally, because I think until there is a series of cases domestically in order to try and clarify some of these really important issues and how they apply in a withdrawal agreement context, whether that's the Windsor framework, which is the focus of the research today, or my own kind of area in part two, the citizens' rights element of the withdrawal agreement, it kind of feels to me that the public education recommendation can't really be achieved without that kind of in parallel key strategic litigation being taken forward to ensure that there is clarity, not just for those of us who are really interested in these areas, but for the wider understanding across the UK.
Who would like to take it?
I try to field that quite quickly. It is a really important point that all of what's going on within the withdrawal agreement will only be fleshed out and thrashed out through litigation. I suppose what we're trying to make the point is none of this is conceptually particularly difficult. And the court's had almost half a century of dealing with a lot of these issues. So sometimes it can be taken with a pinch of salt when people say, oh, this is very complex. It's detailed, but there is a logical follow-through from EU law of how ideas like non-diminution of EU law protections continue to exist in the space of NI after Brexit. And I suppose we've already seen this strategic litigation in play. The NIHRC's reference over the Illegal Migration Act is a really good example of doing exactly this function, the really active intervention in cases like Dillon have also fleshed out these ideas. And I suppose we're reaching the apotheosis of it as these cases make their way to the highest level of the courts. And the interesting thing is, this paper almost talks about, well, for most of its length, how well we understand this set of remedies that are in play. And it's only when you get into chapter 5 that you get into the, well, the what if scenario, if there is a failure to properly reflect the scope of these remedies and where we go next in terms of the withdrawal agreement process. And that's where it goes into these committee system questions.
If I may, I would just add to this. I think one of my primary concerns in setting all of this out in a lot of detail is that we've seen the Supreme Court get rather creative with how it understands EU law and how EU law is meant to work and how the withdrawal agreement operates. And I think a lot of what we aim to do here is to just make it clear that actually this shouldn't be one of those areas where there's a big debate. I'm thinking here specifically of the Lipton judgment, which I am happy to spend the rest of my life talking about, and the many myriad issues I have with it. But there's just random, in some instances, I've seen certain comments made in judgments where I've just gone, this seems almost like a deliberate drawing of a line of divorce, if that makes sense, from pre and post Brexit that isn't warranted in this particular case because the same principles continue to apply and should. And I just think it's essential that we make that point. It should be raised in litigation where possible, but we should make the point more broadly so it doesn't become part of the public narrative of the effects that Brexit have had, if that makes sense.
Yes, I wonder if I might just jump in if we're sort of having a free-flowing question and answer session, and I'm conscious of the time, and it really follows on from what Rhys asked. I come to this, well, firstly, actually, really what I should say is to thank very much the Commission for having commissioned the report and to thank everybody who worked on it, because it's such a broad and expansive and, for that matter, in-depth look to form a bedrock of our consideration going forward. For my part, the Windsor framework, which is the thing that I'm slightly caught up with at the moment. And I come to this from a rather jaded practitioner's perspective, if I can put it that way, having been through 2.5 days at the Supreme Court. It would be difficult to be anything other than that, really. So whilst I agree that the principles of EU law are pretty well established and clearly, and very clearly actually, articulated in this report, and the remedies are too, that's not really the issue. And this is what bears on what Rhys was saying. The issue is its application, and particularly when you come to Article 2, where everything gets a little bit frenetic, to be perfectly honest. From a practitioner's point of view, in order to generate the kind of litigation that's going to produce the jurisprudence that helps explain what some of these concepts are, I mean, like, for example, and not dealing with the legacy point at all, what does the UK in respect of Northern Ireland mean? What does in respect mean? That's a pretty heavy thing, because you could end up with a very interesting division between GB and Northern Ireland, which practitioners will be eager to exploit in a number of respects. So, and what, for that matter, does community mean? which is a sort of almost a related concept. So you're going to need some litigation to produce the jurisprudence from which we will start to look at that and know whether we get into your speculative area in the final chapter, which I must say I'm rather looking forward to getting into, and we may actually end up getting there. But turning back to the point I want to make, from a practitioner's point of view, in order to generate some of that litigation in relation to Article 2, given that we are waiting for the Supreme Court judgment, and I think it's pretty fair to say with experience that no judge a judge may not even take a case that relates to the issues that are still in play as a result of that appeal by the Secretary of State for Northern Ireland. And even if they took the case, they're very unlikely to rule on it until they hear from the Supreme Court. So my question is this: what can we do that doesn't tempt the other side into an argument that's, oh, no, we can't go down that route. This is all caught up with matters before the Supreme Court on which we're waiting to hear their deliberations. How can we still explore through litigation Article 2 and not be constrained or affected by an argument like that?
But before I pass that to somebody to answer, I slightly underplayed the role of Reese and Munya today. Obviously, we've asked them to, to be available online, not just to ask their super questions, but also to share their experience. We have two very esteemed colleagues who can shed a light also, as well as explore with our experts. So thank you both for being available and for being here. Can I pass you on now to Colin? Is it whoever would like to take this one?
Well, I'll go first and try to be brief and then open out. I suppose the issue is that Article 2, as Aoife made clear, has multiple strands to it. And when you look at a case like Dillon, you're talking about the non-diminution strand as it relates to a directive that isn't mentioned in Annex 1. There is a host of litigation that could be happening around not fully matching dynamic alignment to the Annex 1 directives that can still happen because it's frankly a completely different element of Article 2, and it's not affected by needing to wait for the Dillon judgment. Even outside that context, the Dillon judgment is only ever going to give us, in terms of its specific application, an answer on did the Victims Directive have direct effect or answer. It might actually end up being a very narrow judgment on a particular element of Article 2 and how it works. It could be that the Supreme Court does something more expansive and potentially, in our view, more destructive of the operation of Article 2. And if it does that, well, then we're going to very quickly go through the elements of Chapter 5 of this report. But even...
That's the bit that I want you to contemplate, because at the moment, one doesn't know whether they're being narrow or broad. They are most certainly being invited to be broad.
They aren't being invited to be broad.
Because the Secretary of State has seen how through Dillon, which was actually supposed to be nothing at all to do with this. I mean, its primary focus was all to do with a way of resolving the harms that have come through from the Troubles. But because of the way the argument was mounted very, very creatively in relation to the Windsor framework, it then opened everything out. And the Supreme Court is being invited to take a broad look at direct effect, what non-diminution means, that sort of thing. And so what I'm asking you to contemplate is, because that's the argument you may be faced if you try to take a case to court, but it could touch that. You don't know it's not going to, so we'll wait and see what it does do. So bearing that in mind, what can we do that can keep us out of that kind of argument for people who want nonetheless to use Article 2?
Well, I suppose I'll finish up quickly there. That's almost getting the Supreme Court into a third rail territory. It's a very dangerous thing for the Supreme Court to contemplate touching in a way that radically narrows the scope of Article 2 because that will open up all of these remedies, and it will quite quickly become apparent that the Supreme Court's word on it is not the final word on the application of Article 2 as we roll into this specialised and joint committee system and then on to the arbitration system. But if the Supreme Court chooses to go into that space, it will lead to a period where there is uncertainty as to how Article 2 works. And one of my colleagues might want to pick up on that.
Just very briefly, if direct effect is gone, so is Article 2. There's no using Article 2 without direct effect. It'll function like, you know those ministerial statements of compliance under the Human Rights Act? It's a minister's opinion, but who cares? That's how Article 2 will function if there's no direct effect. If there's no direct effect, you can't use it in domestic proceedings. What's the point of it? But in answer to how do we deal with Article 2 while the non-diminution side of things is being worked out by the Supreme Court, I mean, the dynamic alignment aspect is pretty powerful, and it hasn't really been litigated in terms of what it means for the equality directives. VL is an example that we go into in the report in terms of disability rights and the appropriate comparator. The DDA needs to be amended. I think, though someone might correct me, the appropriate agency for that, well, I mean, the appropriate agency for the implementation of EU law in most regards used to be the Executive Office before Brexit. I think it still is. Send a pre-action letter to the Executive Office and see what happens. You know, these are the sorts of practical, like, out-of-the-box thinking that might shine a light on aspects of Article 2 that Dylan has nothing to do with. I mean, yes, there's a lot that Dylan is looking at. Direct effect is a key precondition to the use of Article 2. Without it, there's really not much point to it. But while that's in the ether, and as Colin said, if it goes, we are in sort of third rail territory here. And we need to go through the specialized committee, the joint committee, possibly arbitration, and all the way to the CJEU to see, well, does Article 2 have direct effect or not? I would be shocked if the CJEU said it didn't, because it would, again, be largely superfluous. But in the meantime, there's quite a lot of gaps in equality legislation and equality laws as they apply in Northern Ireland. And the dynamic alignment aspect of Article 2 remains live until it doesn't. So we can possibly use that.
Yeah, sorry, just really briefly. I just wanted to come in and say that this question, this point, the way we're looking at research and the way we're using research is so important to help us explore these issues because it feeds into our work right across the piece. It feeds into our policy work and how we think about Windsor Framework Article 2, how we use it to advise government to say you should be doing X, Y, and Z to ensure compliance. But it also sets the groundwork for our litigation work. You know, the Legal Migration Act case that we took in our own name is an example of that. You know, we commissioned the research, we did the in-house work, we did the thinking, we made some policy recommendations on the legislation as it went through. And then whenever government didn't take our advice, we used our powers in litigation to take action on it. And it just shows how all these parts of our work kind of tie together. So this research, Manya, these questions have to be answered, but as the more we have this research as the ground kind for us to build on, we can use that, and other people hopefully will be able to use it as well to make sure we are giving effect to Windsor Framework Article 2 in all its elements, whether it's the non-diminution bit or the keep pace bit or whatever.
My main job today is to keep to time, so I'm going to do that. But I want to leave the final word where it should be, which is with our head of the dedicated mechanism, NIHRC, who has commandeered and commanded all of this work and the tremendous team we have within the Human Rights Commission. So I'm going to let her end. Thank you very much, and thank you to everyone.
Hello, and not to take too long, if you have 3 more minutes, I have, I think, 1.1 piece of information, 1 invitation and 1 request. So I'll not take too long. Claire has been saying just there, just to pick up from where she left off, really, about the connection between this work and everything else we do.
So really, just first of all, to add my thanks and to say, to really underscore that, and that we will carry this through, and very much the way Claire pointed to the thread from the advice work through to potentially strategic litigation. You can see right away, and I'm sure you want to take it away and digest it and hopefully talk to us a bit more about it, but you can imagine how the next case that comes up, we'll be sitting and looking at this piece and thinking, okay, what are the reliefs we seek? But in addition, the range of reliefs set out will make us maybe think differently again about the merits of any case that comes forward. Okay, do we think differently about whether or not this is capable of challenge through the courts based on the wider perspective that's been brought? So hopefully that gives you a sense of the value. Second then is just to tell you a little about forthcoming work. Sylvia, who's online with us today, you'll recall co-authored with Professor Charlotte O'Brien a piece of research on frontier workers a couple of years ago. And Dr. Ivanka Antova is at the back there. She has been working with Sylvia, but also in a three-way partnership with Anne-Marie O'Kane, Border People, and a group of advisors that Anne-Marie convenes to look at that research and to take it forward into case studies and analysis and looking at what's happening on the ground with a view in the new year to producing some case studies and materials that we hope will be useful to decision makers, individuals, and advisors. So watch this space, we'll be in touch with you about that one. Briefly to mention a forthcoming research project we hope to have out shortly in terms of a call for tenders. We'll be looking at the human rights implications of cross-border cooperation in the field of criminal justice post-Brexit. So there's been some scholarship there in terms of the practicalities. There's been some work by parliamentary committees, but it's somewhat dated. So the question for us is, what are the human rights implications and how does this connect to Windsor Framework Article 2? How do we think of diminution in that context? So on to practicalities. There are evaluation sheets. We would love to tailor these events to suit your needs more effectively. So please be very grateful if you take a couple of minutes and tell us what we can do better. And finally, thank you to those online. We're saying goodbye to you, and a request to everyone in the room, please stay for lunch. Tell us what you think. Ask us hard questions, really hard questions for any of these guys that have time to stay. Easy questions for me, and thanks again. Hope to see you soon.